Thank you, sir. All right, at this time, I'd like to call the Caswell County Planning Board meeting to order for Tuesday, March 28th, 2023. We have the agenda in front of us, but before we go to the agenda, I'd like to recognize a former member of ours, Mr. Leon Richmond, who passed away last week. He served on this planning board for over 10 years and was very instrumental in the board, and we really missed his leadership, but he passed away last week, and just like to give prayers and condolences to his family. I just want to mention that before we start. We have the agenda in front of us. Have all of the fellow board members had a chance to review the agenda? Hearing no feedback, I'll entertain a motion to approve the agenda as is.
I make a motion that we approve the agenda as is.
Second. Motion by Mr. Foster, second by Mr. Daniel to approve the agenda. All those in favor, please let me know by saying aye.
Aye.
All those opposed, like sign. Motion carries. Next, we have the approval of the planning board meeting minutes for February 28th, 2023. I'd like to thank Mr. Hoagland and his office for preparing those minutes, as everyone had a chance to review. All right, hearing no feedback, I'll also entertain a motion to approve the minutes as is.
I make a motion to approve.
Motion by Mr. Harris, do we have a second?
A second.
Second by Mr. Thompson to approve the minutes. All those in favor, let it be known by saying aye.
Aye.
All those opposed, like sign. Motion carries. Item number 4 on the agenda, public comments. We have one individual signed up. Is that George Goo?
Yes.
Sir, Chair recognizes Mr. Goo. If you could state your name and address for the record, please.
George Dogu, 7892 Elizabeth Drive, Oak Creek, 7310.
Yes, sir. And would you like to address the board?
I'm excited that we're back here again on the solar plan that we established. After the last board meeting, we went back and people were asked as to the manufacturing of the solar panels and what materials that constitute the panels themselves. Solar panels, as a matter of fact, as a result of the fusion of silicates, the white sand that we see that is fused up to the temperature of 1,000 degrees and it burns completely. It's at that point itself that the wires are connected, and that's how the panel works. And they're done within silver aluminum cases, so they do not contain any contaminants that can destroy the soil. And it's that stage itself that has been a cause of concern. And I think it's going to be a valuable project for the county and for the community. Because based on the amount of power that is going to be generated, we can negotiate with Piedmont Electric to see how they will reduce rates, or at least keep rates at a certain level that will benefit the community. So it is not a project that is come to destroy the community. Right, it's a project that has come to add value.
Thank you, Mr. Goo. All right, next on the agenda, we have unfinished business, watershed review board appeal of chairman's motion to dismiss. At this time, the chair will recognize our planning board attorney, Mr. Bob Hornick. Mr. Hornick, if you could please maybe give the board some background information as to how we arrived here and then the procedure moving forward.
I'll give you the thumbnail sketch of how we arrived here, otherwise we'd be here all afternoon and probably tomorrow. But in any event, the appeals were filed from the permits issued back in 2021 now, I guess, for the two Sunrock facilities, Prospect Hill and Burlington North, I guess is what we're calling it. After various proceedings, Sunrock made a motion to dismiss the appeals. Those motions, that motion to dismiss was granted based on an order signed by chairman in January of this year, January 17th, I think it was. And we've had appeals filed by the Sunrock appellants, well, not by the Sunrock appellants, but by the appellants from the chairman's decision to the full watershed review board as is provided by statute. So here, what had happened was that the chairman's decision was to dismiss the appeals. There's now an appeal to the full board to see if the full board wants to affirm, that is to agree with Mr. Johnson's decision, to reverse, that is to completely disagree, or to modify somehow. Now, we've given everyone an opportunity to submit briefs. I think we have a brief from the citizen appellants, I'll call them. We have some information that the NAAC appellants have also just handed up to us today. That's the calendar and the timeline. And I think the appropriate process today would be to give the appellants an opportunity to address the board, to iterate or reiterate your arguments, then to give the county and Sunrock an opportunity to address the board should they desire to. And then we as a board can deliberate. You may need to go into a closed session so that I can give you some legal advice if you feel that it's necessary. But the goal is to try to make a decision here today. And but I also want to reiterate to the board that if you're not comfortable with that, if you think that there's something that needs more discussion or more thought, there's no rule that compels us to make a decision today. I mean, I know we all want to get this over with, but we want to make sure that we're giving it as much attention as we think it needs in order to make proper decisions.
And Mr. Hornick, once a decision is made by the board, is that decision appealed?
Yeah, it can be appealed to Superior Court. Okay. So what I think the process would be is, I mean, I don't know what decision you guys are going to make here today, but when you make a decision, whether it's today or some other time, we'll reduce it to writing. We'll get it signed by the chairman of the board on behalf of the board, and then we will circulate the decision, and that will become the appealable decision to Superior Court if there's a bill to appeal.
Thank you, Mr. Hornick. And so we should let the appellants address the board first.
Appellants go first, then the appellees, and then we see where this dog and pony show takes us.
Okay. All right, well, if there's no objection, the chair will recognize Mr. Connor to present his arguments before the board.
Thank you, Mr. Johnson. Do you prefer that I stand or seated?
Totally up to you.
I think I'll just stay seated since everybody is sitting. My name is Jim Connor. I represent most of these folks back here in the audience and some more folks, about 55 citizens of Caswell County. Start with, we've had a few lose heart, get worn out, if you will, and drop out. But I think we're in the high 40s at this point still. Caswell County citizens who have appealed to their board, their watershed review board, for some belief here. What happened was, as you undoubtedly recall, is that two permits requested by Sunrock were issued by Mr. Hoagland. And I've got all the dates in my brief, and I presented questions about the dates. I'll be glad to answer those, but I'm not going to bore you with going through every day. But Mr. Hoagland issued those two permits after the moratorium that the county commissioners passed was in effect. Moratorium said thou shalt issue no permits, but Mr. Hoagland issued it anyway. Now, we know that Mr. Hoagland is a very intelligent man and a diligent man, and he didn't just do that by accident, I don't guess. And so what we think is that he got convinced by Sunrock that Sunrock had vested rights, is a legal term, so that they didn't have to pay attention to the moratorium. They could get their permit anyway. Well, because that's the argument Sunrock's made. We believe, and I believe as an attorney, that that argument is incorrect. I do not believe they have vested rights. Pardon me? I'll do my best. I'm facing the wrong way, but I'll do my best. So I'll try not to shout at the board and also be heard. So these permits were issued during the moratorium. And we say they should not have been issued. We say that those permits are invalid because they were issued during the moratorium. And that this board should invalidate those permits. That's what we came here for to start with, a year ago, 2 years ago, something like that. As you may remember, Sunrock sued my clients in Superior Court for bringing these claims before this board. And we spent months and months going back and forth with legal stuff in Superior Court until Sunrock finally dismissed that case, having wasted my folks' time and money. So now we're back before you. The delay has not been any fault of these folks, these neighbors of yours. They've been trying to get heard in front of you. And that's what we're asking for still, is to get heard. Sunrock filed a motion to dismiss, as Mr. Hornick mentioned. And that motion to dismiss said that this board does not have. Good song, but probably don't need it right now. The motion to dismiss said that this board doesn't have the jurisdiction. That's a legal term you don't probably are familiar with, but if you're not, what it basically means is the power or the right to hear this case. They said you guys don't have the power to hear this, and it needs to be dismissed for that reason. Well, Superior Court has already said, in response to some of these citizens who've appealed, that Superior Court's not where we need to be, but for this board is where we need to be. And so we've got the court saying, don't come here. We've got the board, a motion before the board saying you can't come to the board either. And then unfortunately, and Mr. Johnson, no offense whatsoever, but the chair did grant that motion in his initial order. As Mr. Johnson and Mr. Hornick have said, you've got the right to reverse that initial decision or modify it or affirm it if you think it needs to be affirmed. But what I would urge you is that original initial order did a couple of things. One, it did not decide the question explicitly of jurisdiction. It didn't say there is jurisdiction or there isn't, but it did go ahead and decide the whole case. And if it decided the whole case, that meant that Mr. Johnson and Mr. Hornick must have felt that this board does have jurisdiction. Otherwise, he couldn't decide the whole case, because the whole point of saying you don't have jurisdiction is to say you don't have the right to decide the case. And so implicitly, or without saying it in so many words, that decision decided there is jurisdiction on this board. But the problem with the decision is again, no offense to Mr. Johnson, but it went further than it should have. Because the statute says that when an appeal like this comes to this board or any of the other county boards or any county board in the state, that there has to be an evidentiary hearing. And I've cited that law in my brief and tried to keep that brief pretty short and to the point. But on page 2, I cite the North Carolina General Statutes 160D 406. And subparagraphs A, D, F, and G. And those subparagraphs say that the hearing shall include the opportunity to present evidence, that witnesses will be sworn, and if necessary, subpoenas can be. The subpoenas aren't a necessary part of it, but that's the kind of hearing it is. The court-like hearing. Attorneys call it a quasi-judicial hearing. And the statute goes on to say, and this is an actual quote from the statute, every quasi-judicial decision shall be based upon competent, material, and substantial evidence in the record, close quote. So it was improper. It would be improper. We don't have a final decision court yet, but it would be improper for this board to make a decision that doesn't allow my folks and Bateman's folks to put on evidence so that you can decide the case properly. Now, going beyond this sort of procedural things, the decision also decided that the permit choice statute applied here. Nobody had argued permit choice. There is a permit choice statute, not saying there isn't, but nobody had argued that. And it just doesn't apply. And in the brief, I've said why, but and I've attached the most recent Court of Appeals case saying why, which is you have to have a complete application in place before the moratorium starts. Excuse me. Before the moratorium starts for permit choice to apply. And if you do recall, permit choice is that very odd statute, and I tip my hat to the developers and their lobbyists. They got this passed. Nobody else has the right to do this, but the developers have the right, if a county changes its ordinances, to pick, do they want to follow the old ordinance or the new ordinance? And I say that's extraordinary because if you think about it, what that statute does is takes the power away from the county commissioners and the elected representatives of the county to change the ordinances and for those to have effect. Because a certain component of the population, developers, can say we don't care to change the law, we're going to follow the old law. That's our choice. But for better or for worse, wise or unwise, the legislature passed that and the developers have that right. But because it's an extraordinary right, we need to be careful about it. And the statute specifically says in the Court of Appeals in Asheville versus Asheville Planning Board specifically said that if they're going to get this special right, they've got to have a complete application on file before the moratorium starts. Sunrock had no complete application for, I keep saying either of these permits or two permits, it's 4 permits, 2 for each of 2 different sites, 2 for Burlington North, 2 for Prospect Hill, 4 permits altogether. But none of those were complete before the moratorium started. The Prospect Hill is those 2 permits are real easy. They didn't even apply for those at all. Nothing until 2 days after the moratorium started. January 6th it started, January 8th they applied. Burlington North is a little more complicated. They did apply, they did make their first piece of paper applying for those before the moratorium. But the county, Mr. Hogan came back and said, well, it's not complete. You've got to get us some plans here and some things like that. They didn't get those in, making the permit application complete until well after the moratorium started. And then everyone agrees that the permits were actually issued during the moratorium. So the motion to dismiss asks this board to say it doesn't have the power to hear this case, for these cases, these 50 people. The initial draft decision, if you will, says didn't really get to the jurisdiction part, but seemed to assume jurisdiction when it had decided the whole case. Statute says clearly, don't do that without an evidentiary hearing. People have the right to come in here and put on evidence before you make a decision. So you're making a good decision based on evidence, not based on what you read somewhere or what you assume or what you know, but it has to be the evidence that comes into this court. Quasi-judicial board. And then even if you get past those 2 things, the decision was incorrect because permit choices. So we would ask this board, and I've tried to keep this pretty brief, but I would welcome questions and discussion. We asked this board to make a different decision than the draft decision or the initial decision was. To say, first, yes, this board does have jurisdiction because it clearly does. And I'm going to circle back around to that in just a minute. But yes, the board has jurisdiction and set it for hearing and not decide or reverse the part of the draft decision that says, here's I'm deciding the whole case, because that shouldn't happen. And again, no disrespect at all, but that shouldn't have happened. That's the statute says you got to have the evidentiary hearing first. And even after you have that evidentiary hearing, if the evidence is what we all think it's going to be, the answer is going to be the permit choice statute doesn't apply. what you're really gonna need to look at is vested rights, moratorium. But that's looking down the road. Right now, the question this motion brought before you is, do you have the power to hear that? Now, the county's Unified Development Ordinance grants this board broad authority to hear appeals of the Watershed Administrator's action. And I'm sure you know this already, but that was, Mr. Hoagland has a whole bunch of hats in his office, I think, and one of them is Watershed Administrator. And so that's what the hat he was wearing when he made these decisions. It says, quote, this is your ordinance, Caswell County ordinance. Any order, requirement, decision, or determination made by the Watershed Administrator may be appealed to and decided by the Watershed Review Board, that's you, as specified in section 10.10.6, close quote. That's section 10.10.2.1 of the Caswell Unified Development Ordinance. Likewise, the North Carolina General Statutes, the laws of the state, say that this board has the authority to hear challenges to the county's vested rights determination. And again, I don't particularly want to talk about vested rights, but I know Sunrock does, because they say that's why they don't have to pay attention to the moratorium. And so General Statute section 160B-108H as in horse says that if you're claiming that kind of a right, a vested right, you submit that information to the zoning administrator or other officer designated by a land development regulation, who shall make an initial determination as to the existence of the vested right, and then it gets appealed to a board like this. It doesn't get down to specifics because it's a very general statute, but the employee makes the decision, and then the board hears the appeal. And then, as Mr. Hornick said, if we have to appeal it again, that would be Superior Court. But right now, we're not in Superior Court, we're here. And we're simply asking this board to decide this motion first, which is to certainly have jurisdiction, right? Deny the motion, and then set this for hearing so that you can hear evidence and make a decision on the issue that was brought before you by your neighbors, 55 of them, about a year and a half. I do want to address one sort of red herring that's been thrown out there. There's been a lot of talk by Sunrock about, geez, we'll have to spend 2 weeks just hearing standing arguments for these folks. And and I don't, maybe that's sincere, and certainly Jeff, I know you're a sincere guy, but maybe that's sincere, but it isn't true. I've been doing this for 37 years. I have never seen a standing argument go longer than half an hour or an hour. It's something you argue to the judge, or in this case, to this quasi judicial board. We can do it on affidavits. We've talked about, if we really want to take live evidence, if this board wants live evidence, in other words, a witness in a witness stand on the issue of standing. And standing is the issue of, so we've got the issue of, do you guys have jurisdiction? Do you have the power to decide the case? Then standing is the technical issue about, do these folks, are they the right people to bring these issues before you? Do they have standing? It's a fairly complicated legal doctrine, but when you do environmental law, land use law like I do, every case you have comes up. And so I've dealt with it 100 times. There's never been a 2-week hearing, never been a 1-week hearing. There's never been a 1-day hearing. It's for me. Bob may have had one. I haven't. So, well, we'll find a way to make sure you folks are not taken away from your job, or your retirement, or your farm, or whatever it may be, for 2 weeks just to hear stand. We're not going to do that. We'll find a way around. Jeff and I and Valerie and Bob will talk about it, and we'll figure that out. You're not going to hear that. I'm going to spend 2 weeks doing it. Okay, we'll spend an hour or two doing that, and then you hear the evidence, and that's not going to take long either. There's not that much evidence to be heard. We've got some folks that want to be heard because they're mad about this. They'll want to talk some, but it's not for hours and hours. It's for 15, 20, 30 minutes, something like that. And I think we can get in and out of here in a day. Maybe it's 2 days, but it's not 2 weeks just to get started. It's nothing like that. So to the extent you've been concerned about what on earth are you going to do if you're called in here for 2 weeks, I don't have the intention to ask. Frankly, my folks don't want to pay me for being here for 2 weeks. I can tell you that for sure. We're going to find a way to do it quick. And but proper. So that's our argument. Again, we'd ask you to deny the motion to dismiss. That's all that's really before you right now. Say, yeah, we've got the power to hear this. That's what the statutes say. That's what the ordinance says. We've got the power to hear. We've got jurisdiction, legal terminology. And then after that, we'll talk about when to set it for hearing so we can get this thing resolved and done with, and y'all can stop worrying about it. Thank you very much.
Thank you, Mr. Collins.
Yes, sir.
Chair now recognizes Ms. Valerie Davis.
I'm delighted to be here today. I will tell you, I'm not going to make many, if any, legal arguments. What I'm going to ask you to do is look at the calendar I gave you, because even the 4-year-olds in my Sunday school class understand the calendar. Last Sunday, we were talking about Palm Sunday, and they looked at Jesus on the donkey, and they said, oh my goodness, he's grown up. So they understood. There are babies, and then later there are grown-ups. So all you really have to understand in this case is that one day comes in front of another, right? And certain things happen in this case, and you just need to understand and remember what happened when, okay? And that's why I did the timeline, which is kind of convoluted, but there are only a few important dates. Like if you look at the bottom of this calendar, there are 365 days on the calendar, right? But only a few of them get called out at the bottom, like holidays and observances, right? Only a few of the dates are important for you to remember. The first date, though, I want you to know about and remember is that your environmental regulations existed in 2013, okay? These were passed in 2013. They were in effect on the day that every day before Sunrock submitted its applications. All right, for the watershed permit, and the SNEA permit, these regulations existed. And those regulations required, if you look on page 1, I highlighted this, a spill containment plan. So Sunrock can't say, we didn't know we needed to present a spill containment plan to have a complete application, because it's been in the UDO since 2013. And you can look at that. Now they submitted this application in December. Here's another important date. This is on, oh Lordy, page 4, 2019, 12/13, they submit a watershed protection permit, okay? A set of plans, a check, there's 8 pages there. On December 16th, Mr. Hoagland, who I think did a fine job here, except for one thing. He stamped it received, and then by golly, if he didn't turn right around, and 6 days after they submitted it, 3 days after he got it, he actually told them, hey, you're gonna need, this is on page 4, you're gonna need a SNEA permit, you're gonna need a DEQ determination of on-site ponds, you're gonna need a spill containment plan, you're gonna need an environmental assessment application, you're gonna need a site plan showing 30 feet undisturbed and 70 feet vegetated buffers from the perennial waters due to the SNEA. He told them they needed all these things 6 days after they submitted their application. Okay? If I'd been Sunrock, I think I would have gotten all this together as soon as I could and submitted it to Mr. Hoagland, but that's not what they did. If I'd been Sunrock, I would have submitted stuff and said, okay, when's my application going to be complete? When's my application going to be complete? Because your rules say that Mr. Hoagland only gets 15 days to decide when it's after he's got a complete application. He's only got 15 days to decide it. All right. When is my application complete? When is my application complete? I haven't seen any evidence of that. I haven't seen any evidence in the documents on the website or anything I've seen that there was any environmental assessment application done, but never mind that. If you look on page 5, it wasn't until December 20th 21st, 2020, that's on a year later, that Caswell County passed the HIDO. So the HIDO is the law or the law, if you're gonna do permit choice or whatever it's called, what is it called again, Jim? Permit choice. If you're gonna give them permit choice, they didn't have a complete application in December. So this is all they get to choose between. They have to comply with that HIDO. And that's what Mr. Hoagland didn't make them do. So I don't know if this moratorium thing that was going on caused, Sunrock and Caswell County just kind of sit there and do this and think about things and hire lawyers to do memos. I don't know what was going on. All I'm telling you is that in December 21st, 2020, the HIDO was adopted. And Mr. Hoagland did not tell them they had to meet that HIDO before he issued those permits. Now, if you look at that, the moratorium, I guess, is adopted the next January. I don't know anything about that moratorium. I don't know what that moratorium did. I don't know this because this is really not my field of law, but I know you can't put something in place that says we're never going to decide your permit. So that's why I think that moratorium is kind of a smoke screen. I don't know what the moratorium does or doesn't do, but I'm just telling you, January of 2021, Mr. Hoagland says, okay, it looks like you've got a sediment and erosion plan that confirms that you have stormwater management. Because again, back in 2013, you told them they had to do that. Okay, so when they submitted their thing, they had to do that, and they still hadn't done it. That thing didn't even exist. I don't know when they gave it to Caswell County, but if you look on the right side of page 5, that erosion plan didn't even exist until April. So they couldn't have given it to Caswell County before April. Okay. And then the spill prevention containment plan, again, that didn't exist until April either. So I don't know when again they gave it to Caswell County, but it didn't exist at the time that they filed their application. So their application was not complete in December. Now, I don't know when you want to call it complete. Mr. Hoagland called it complete in January, right? But by the time January rolls around, you've got the HIDO in place. So I don't know why he didn't apply the HIDO, because there's never been any suggestion that the HIDO is not valid. And the HIDO has specific things Sunrock has to do. And as far as I can tell, they didn't do them. So if you look at the dates in here, the spill containment plan had to be submitted in the beginning. They knew about it, or they should have known about it had they read your ordinance, which was in effect in 2013. They didn't submit it when they submitted all these permit applications. They submitted them later, but Mr. Hoagland was still waiting for other things because it wasn't until January 4th and January 5th of 2021. He said, look, maybe by then they were saying, when is my application going to be complete? When is my application going to complete? He was saying, okay, well, you still need to submit these things. Okay, and he told them, and by golly, they submitted them on the 7th and he issued those permits, and here we are. I'm just saying, all you have to do is look at the calendar. All right, and he should have applied the HIDO, and he didn't. And it's just as simple as looking at the dates on the calendar. That's all I have to say.
Thank you, Ms. Baker. Counsel for Carolina Sunrock.
Yes, thank you. Good afternoon, Jeffrey Realtor from Morningstar Law. Here on behalf of our client, Carolina Sunrock LLC. You may be used to seeing my partner, Bill Bryan, who's out of state for some travel plans that he had. So he'd be here if it wasn't for that, and certainly gives his best, and which is he was able to be here today. We are here, as Mr. Hornick described, because the appellants of Peter Chairman Johnston's.
Could you speak up?
Rule.
Could you speak up?
I'm addressing the board.
Yeah, well, I can hardly hear you either. I'm so sorry.
We are here because certain of the appellants appealed Chairman Johnston's ruling granting Sunrock's jurisdictional objection and dismissing those appeals that appeals allowed under General Statute 160B-406. We thank you for your time and your attention and patience as this matter continues. We've already submitted motion papers in support of our motion to dismiss and argue this issue once before. So I will be brief. I'll try to be brief, but I'm not going to repeat everything that Mr. Bryan argued to you in November of last year. In short, we are asking that the board uphold Chairman Johnson's ruling because there was no error. For all the reasons that my colleague, Mr. Bryan, explained, he argued this matter months ago. This board lacks jurisdiction over the issues raised by the appeals, and therefore they should be dismissed. Sunrock's motion to dismiss was about this board's jurisdiction. Chairman Johnson described it as authority, which is a pure issue of law. Jurisdiction is the power of the board or any board or court has to hear a particular case. In other words, boards like this one have specific jobs to do, and anything beyond the board's jurisdiction is not its job to take on. Sunrock's position is and always has been that the appellants brought their complaints regarding Sunrock's projects to the wrong place. The Caswell County UDO is plain and states that this board's job is to hear and decide appeals from any decision or determination made by the watershed administrator in the enforcement of the county's watershed protection regulation found in UDO Article 10. This board's only job is to decide appeals of decisions or determinations made by the watershed administrator regarding the application of the county's watershed regulations. In this case, Mr. Hoagland, wearing his hat as the watershed administrator, issued watershed protection permits to Sunrock pursuant to the watershed protection regulations in Article 10. This board's job, therefore, is to decide whether Mr. Hoagland properly applied those watershed ordinances. If an appellant wants to argue that Mr. Hoagland made a mistake in interpreting or applying those watershed regulations, that appeal belongs here. On the other hand, any argument that Sunrock's project violates state or federal law, or a building code, or the HIDO, or a moratorium, or any other law other than Caswell County watershed protection regulations must be dealt with elsewhere. Sunrock submitted this motion as a jurisdictional objection because the appellants are asserting arguments under various statutes, ordinances, and regulations that are not part of Caswell County's watershed protection regulations. Sunrock's view that the Watershed Review Board is not the right place for these people to be making these arguments. They point to rules and regulations that are not the ordinance that Mr. Hoagland applied while reviewing Sunrock's permit applications. This board, therefore, is not the right place to determine whether Sunrock's projects comply with the rules and regulations that are separate from those that Mr. Hoagland reviewed and applied as the watershed administrator. Board chair agreed with that position. Bottom of page 4 states, the WRB chairman finds that the watershed administrator's authority under the watershed protection regulations extends only so far as the UDO allows, and that review for compliance with state or federal regulations or with county regulations which are not found in UDO Article 10 are beyond the authority granted by UDO Article 10 to the watershed administrator and the watershed review. Based on that conclusion and others, the board chair dismissed the appeals. We've heard many arguments today, and some of which were contained within the written submission by Mr. Connor. And the first one was that it is premised on Mr. Connor's conclusion that Chairman Johnston did not decide the jurisdictional issue raised by Sunrock's motion to dismiss. And that is an incorrect premise. I just read you a passage from the decision that squarely addressed the basis of our motion. Sunrock argued that the board does not have jurisdiction to review other rules and regulations, and the chairman expressly found that he and Mr. Hoagland did not have the authority to review rules and regulations other than those in UDO Article 10. That conclusion alone was enough to support the dismissal of these appeals. Mr. Connor and Ms. Bateman are strong advocates for their clients, but they want to continue to focus on everything else, including permit choice statutes, the HIDO, vested rights. But there's no need for this board to consider those issues. If the board agrees with the conclusion that it lacks jurisdiction or it lacks authority, as Chairman Johnson described it, over the issues raised by the appellant in these appeals, the board should uphold the chairman's decision to dismiss them. Mr. Connor next argues that the chairman improperly decided the merits of the appeal without a hearing by addressing certain issues under the permit choice statutes. Again, that is not correct. The permit choice statutes and vested rights have nothing to do with the merits of any issue that can be considered in this appeal. Again, these appeals of the watershed permits issued under Article 10 of the UDO. So the merits of this matter, the permits and the arguments about whether they were properly granted have to do with issues under the application of Article 10 of the UDO. Chairman Johnson did not address any substantive arguments under Article 10 on the merits as Mr. Connor described it, because none of the appellants have raised any of those issues. Chairman Johnson's decision did not touch on any merits of any argument that could properly be before this board. Mr. Connor, Ms. Bateman also argued that Mr. Johnson incorrectly interpreted the permit choice statutes, cites to a court of appeals decision in a case from Ashe County to support his argument. And again, this is beyond the fundamental premise on which the dismissal of Sunrock's motion was based and the decision to dismiss the appeals was based. And actually, the argument proves Sunrock's point. This board was organized to review decisions regarding the application of Article 10 of the UDO, specifically the watershed protection regulations. And now the appellants are asking to analyze and rule on the most intricate details of the permit choice statutes. The Court of Appeals in the Ashe County case was not unanimous on those issues. It's now being addressed in our state Supreme Court. This is not the place for this issue to be decided. And this argument on unsettled and complicated issues of law is exactly why Sunrock consistently has maintained that this dispute that they are trying to bring belongs in Superior Court. And Mr. Connor described it just now as looking down the road, and that's exactly what he's doing, but he's looking down the road to an argument that doesn't belong here, and that this board has no authority to address. We know the Ashe County case. That case is currently on appeal to the Supreme Court. Because it was a dissent in the Court of Appeals. Mr. Bryan and I have submitted briefs in that case. So the legal principles cited by Mr. Connor are far from settled, and we understand them. We also understand cases like Robbins and others that predated the permit choice statutes that would lead to the exact same conclusions that were addressed under the permit choice statutes by Chairman Johnson. We also know the facts of the Ashe County case, and when the time comes, we can address why the circumstances in Ashe County in that case are far different than those described by Mr. Connor in his statement. But this is not the time and the place to get into those details. It's not the board's job to decide the permit choice issues and arguments that are made now by the appellants on these complicated issues of law. And the appellants are simply trying to make this issue even more complicated. They double down on that. So we urge you to disregard those arguments and leave them for the courts to address at the appropriate time. And Ms. Bateman makes a point about HIDO and the timing, and she doesn't know why Mr. Hoagland didn't address and apply the HIDO. That exactly goes to our point, is that the HIDO is not Article 10 of the UDO. It's not a watershed protection regulation. These permits that are being appealed are not HIDO permits. It is a completely different issue, and it's conflating the issues that are supposed to be this board was organized to hear, and arguments that they want to make against Sunrock's permits that belong elsewhere. So in short, We are asking the board to uphold Chairman Johnson's decision to dismiss all of the pending appeals for lack of jurisdiction. If the board upholds Chairman Johnson's decision, those proceedings, these proceedings before the watershed board will complete. And if they so choose, the appellants can try to take to the Superior Court all of the arguments that they have made today. I thank you all for your time and attention and your patience with this matter. If you have any questions, I'll be happy to address them.
Thank you. Mr. Farrell.
My name is Brian Farrell, and I'm representing the Watershed Review Administrator in this hearing today. So my job is not to argue one way or the other on the application. It's simply to argue that my client, the administrator, did his job and he followed the rules in issuing the permits according to the Unified Development Ordinance. So that's my role here. I've heard it from me before, but I just want to mention that again today. And I've got 30 seconds worth of comments and arguments to you. And what I'd like to say is I appreciated the time and effort that went into that order. And I think it addressed very well the question that was presented in the motion to dismiss. Does this board have jurisdiction to hear things like vested rights, federal rules about environmental matters, or state rules about environmental matters, or the HIDO that aren't contained in the watershed review regulations? And the order did a good job of answering that no. Answered that jurisdictional question no. I point to the same part of the order, page 4, the bottom paragraph. It's really clear to me, and I appreciate the clarity. You know, when he says the Watershed Review Administrator's authority under the watershed protection regulations extends only so far as the UDO allows, and that review for compliance with state or federal regs or with county regulations which are not found in UDO Article 10 are beyond the authority granted by UDO Article 10 to the Watershed Review Administrator and therefore to the Watershed Review Board. So that was really the crux of the motion to dismiss as argued to you. It was answered clearly in the order. And for that reason, I think the order should be upheld by the full board, and I appreciate the time and attention that went into your decision, Mr. Chair.
Thank you, Mr. Farrell. So at this time, if any board members have questions for the attorneys, now would be the appropriate time. Okay, seeing that we had no questions for the attorneys, the order would now be the time to go into closed session. I can give some instruction to the board.
Yes, Mr. Johnson, I've got comments.
Yes, sir.
Would it be possible for me to respond very briefly to these arguments?
Certainly.
Thank you, sir. I will be very brief, but first, we did not ask this board to decide anything about permit choice. That came up in our view out of the blue, and the chairman's correct, no disrespect. But we've never mentioned permit choice here. We've never asked you to decide permit choice. That's never been something we've talked about to you. Never anything we put in a brief until now when we had to say it doesn't apply because it came up. That's not us. Okay? We're not asking you to do that. What we are asking you to do is to simply do what the motion to deal with this motion, which is about jurisdiction. Do you have the power to hear this? And honestly, no disrespect to Mr. Farrell and Mr. Rother, the argument that the only thing you can look at is some technical deficiency. You can't look at whether the county had an ordinance saying no permit shall be issued when these permits were issued is absurd. I've never heard that argument in court before, or a quasi judicial board. The law is the law, and the law in this county at the time these permits were issued was thou shalt not issue permits. And so to say that you can approve permits that were issued clearly in violation of the law, unless you consider an argument by Sunrock that there was vested rights, so they didn't have to pay attention to the law. So unless you're going to get into that, these permits were absolutely, unquestionably issued in violation of the moratorium law that was in effect in this county. And to suggest that this board should ignore that and put its stamp of approval on permits that were issued in violation of the law is absurd. That's not what any court does. That's not what any quasi judicial agency does. That's not what you're about. You're supposed to make the right decision. Now, if we have a hearing and Sunrock wants us to argue, well, we had vested rights, and so the moratorium doesn't apply, we can, we can get into all that if we need to. But on its face, as it's been presented to you right now, what you know, beyond question, beyond any attorney arguments, is these permits were issued while there was a moratorium that said thou shalt not issue permits. So you certainly have jurisdiction. If you're being asked to either put your stamp of approval on the permits and say, yes, they're good permits, or to say, no, they're not good permits. You've got jurisdiction absolutely beyond question to do that. You have to have an evidentiary hearing to do that. You don't decide if it's based on lawyers talking to you. You have an evidentiary hearing to hear evidence, but you've absolutely got the power to do that. That's what the law requires you to do. And that's all we're asking. These folks have been waiting, your neighbors have been waiting and waiting for a hearing to be able to be heard on these issues. And we simply ask them to do. Thanks very much.
Thank you.
Ms. Baker. I just find it fascinating that the previous argument was Sunrock didn't have to comply with state or federal law. And now Sunrock saying we don't even have to comply with Caswell County law. I mean, that's just crazy. We don't even have to comply with our own ordinances. Mr. Hogan wears multiple hats. He can't just, as watershed administrator, ignore the fact that there's a hideout out there, or as Mr. Connor wants to focus on, the moratorium out there. You can't just ignore your own law. Now Sunrock's arguing we don't have to follow any law except for the watershed regulations, which we met. But the thing is, they didn't meet them until January. And the problem with not meeting them until January is that other laws came into effect because Sunrock was dilatory, which is a big fancy word for slow and lazy in getting their paperwork done.
Okay, any other rebuttals or counter? Mr. Hogan, I'll address you as the county planner instead of the watershed administrator. We've had very few closed sessions in the past. Should we have our closed session in here, or is there another room in the library where the board can?
There's probably another room in the library where they could accommodate the board and maybe a little bit tight, and I'll be happy to consult with library staff. If not, it may just require a little bit of time for everybody to leave the room, and then you guys can have it to yourself. And I will ask Mr. Chairman too, since I'm now doing the minutes of the meeting, I'm going to turn off the audio and video from the TV. If the chairman or whoever you delegate could keep a rough sketch of closed session minutes, that would be appreciated.
Certainly, thank you. One of the things we'll have to do is have a motion to go into closed session to consult with your attorney pursuant to 143, 318, 11A3, I think is the right statute. So can I have a motion to that effect, then we can go into closed. Assuming it passes the closed session.
So if there's no objection, now I think would be the appropriate time to go into closed session. We can consult with the planning board attorney, and we need a motion to go into closed session.
I'll make a motion to go into closed session.
Second. Motion by Mr. Thompson. Second by Mr. Harris. We go into closed session at this time. All those in favor, let me know by saying aye. Aye. All those opposed, like sign. Motion carries. So Mr. Hogan, we need to go.
Just to let the audience and council know, we discussed process and the board's options, have not taken any actions. So we're here to come back into open session on a proper motion, and then the board can make a decision as it sees fit. Thank you, Mr. Hornigan, and we'll call the meeting back to order. We are back from recess. And Mr. Hornigan, we need a motion to go out of closed session, right, to come back into open session. So I'll entertain a motion at this time. I'll make a motion to go back to the open session.
Second. Motion by Mr. Thompson, second by Mr. Daniel. To go back into open session and out of closed session. All those in favor, please let me know by saying aye. Aye. All those opposed, like sign, motion carries. Mr. Hornick,
I just can entertain a motion from any of the board members of a decision or motion that they would like to see the board consider or discuss.
so at this time, we've heard arguments from the attorneys. And Mr. Hornick, correct me if I'm wrong, but the decision we're making here today is the appeal of the chairman's decision on motion.
Yes, it is. Okay.
So is there any discussion from the board members at this time? Are there any, are we going to take any action on the appeal at this time?
I make a motion, we affirm the chairman's decision.
Okay. Second. Of course, we have a motion to affirm the chair's decision. Motion by Mr. Harris, second by Mr. Daniel. Mr. Hornick, is that the proper technical? We have a motion and the second. To affirm chair's decision. Is there any discussion? All right, hearing none, we'll take a vote. All those in favor of the motion, please let me know by saying aye.
Aye.
All those opposed, like sign. Motion carries unanimously. Mr. Hornick, at this time, this decision is appealable.
Right, what I'll do is I'll get it in written form, circulate it, get it signed by the chair, and then once we have the signed decision for all of that, and I'll do some kind of letter. That's what any time to appeal will begin.
Thank you.
Thank you, board members, for your time.
All right. All right, Mr. Hogan. Next one. Thanks.
Mr. Chairman, I'm happy to pause if you just want to do a couple minutes for recess. If you take it.
Well, that's okay. You never know. Yeah, well, next on the agenda, under unfinished business, item 5C, Solaris Renewable Energy Facility. Mr. Hogan, whenever you're ready, could please give us background information as to where we left off at the last meeting and the path moving forward.
Yes, sir. Thank you, Mr. Chairman. Board members, as you will likely recall, there were primarily three items that were not specifically addressed during and after the public hearing for the Solaris Solar Farm development during the February the 28th meeting. Specifically, those were the groundwater and well study, the traffic impact analysis, and the stream buffer setback requirement within the high impact development ordinance. Included in the packet that you received for this meeting, you should have an engineer's letter addressing the traffic impacts and the groundwater analysis for the renewable energy facility. However, the stream buffer requirement is still up for interpretation. Today, the planning board's task is to interpret the high impact development ordinance's stream buffer requirements and to make a recommendation to the planning department on the intent to construct permit. Again, the planning board has the following options. Number one, to recommend approving the development. Number two, to request modifications to the development. And number three, to recommend denial of the intent to construct permit. Please note that the high note also required that its recommendation be made within 30 days from initial consideration. And that initial consideration took place on Tuesday, February the 28th.
And Mr. Hoagland, it's the planning board's decision today to just make the recommendation, and ultimately the high note states that the county planner ultimately make the decision on issuing the permit.
Yes, sir, that's correct. All right, so there's actually a two-step process on the planning department side. There's the intent to construct permit, which authorizes the green flag for the development, and then there's the actual operations permit, which would take place after the development is complete.
Thank you for explaining that thorough fashion. Mr. Hoagland, there were, if I recall at the last meeting, there were issues about the stormwater and erosion plan. Do we know if those issues were resolved and those questions were answered to the best of your knowledge?
Yeah, well, with regards to stormwater and erosion, I think that's been handled from the beginning. And as we discussed, one of the key things that we look for is that sediment and erosion control permit whenever there's a development proposal for greater than 1 acre. That was sought and approved, and I know Mr. Hubbine can speak to that in much greater detail than I can. What is similar but was still at question was the groundwater and well study. And that's a feature of the high impact development ordinance that's unique to local jurisdiction. And that is one of the items that was covered by the engineer's letter. As I mentioned, the groundwater well study, but then also the traffic impact analysis covered in the letter that was.
Are you satisfied those provisions have been addressed?
Yes, sir, I'm satisfied with it. And you know, the key thing that stuck out to me during the discussion, if this were a different type of a development, I think more scrutiny on the groundwater study may be warranted. But one key note that stuck out to me was that installing a solar farm, you're going down about as deep as you would be putting up a fence. And so when it comes to any sort of groundwater contamination, I think the risk of that is just extraordinarily low for this type of development.
And remind me, and I apologize, I've forgotten your name, sir. What did you name?
Chad Huffman.
Mr. Hoagland. Mr. Hoagland, would it be okay for us to address any questions towards?
Oh, absolutely.
Any questions or comments from the board? Mr. Hubbine, I did have some questions about the easements on this property. In looking at the aerial view of the land, you know if the solar facility will connect to the infrastructure, like power transmission line, or will the power lines be connected along the easement all the way to Sherry Grove Road?
Do not know the answer to that. Chad Huffman, 505 Davis Street, Burlington, North Carolina, civil engineer protocol. I don't know at this time that route has been chosen, but there are two options, both to the north.
I got it right here.
I do have here with me today the owner, Mr. George Orgood, who may be able to address that if you would like for him to come up and speak.
Sure, if there's no objection from the board. The chair recognizes Mr. Orgood.
Thank you. Mr. Keith Hart. That's, I think, he can join us on Zoom. So, Mr. Chairman, I think it says he can share that information with the board at this time.
Thank you.
Mr.
Can
Hart?
you hear? Yes, can you hear me?
Yes, sir.
So it will be connected to a distribution line, which is the same type of distribution line that runs along roads and highways within the county by Piedmont EMC. But Piedmont EMC will not determine that route of how they will interconnect until we actually submit an interconnect application and design, provide a preliminary, like a 30% drawing set. And that cannot be done until this permit is actually granted, or this proceeding is granted. We've been in contact with Piedmont, but they will not determine where, we call that a point of interconnection. They will not determine that until we actually submit an application.
Mr. Hart, can you advise the board as to what options you think the solar facility would have for interconnection?
I can speculate.
Sure.
The Piedmont has, in some areas around the development, they do have some existing easements. They may use those existing easements and then acquire additional easements to get to the site, or they could actually put underground facilities along the ingress egress that's available to the property now from the northern side. So I can't speak to how they're going to do that. They'll do a system impact study and a system facility study, which will determine what the impact is to their system and where is the best location electrically to inject that power. And that's up to Piedmont to make that determination. If I was in Piedmont's place, I would probably run underground conductor along the existing ingress that's available to the site now. So there would be no overhead power line impact along that pathway and driveway.
Thanks for explaining that, Mr. Hart, because at the previous meeting, we did have some concern from neighbors that lived along the easement as to whether or not the power lines would be underground or above ground. So thanks for
Yes. So all the power lines within the facility, other than a couple of poles for protective equipment and metering equipment, will be underground. But I can't speak for Piedmont, but it's going to be really up to them of how they want to route that, because those from the property line out, those are all facilities that will be owned by Piedmont. So the site would not own any of those facilities.
Yes, sir. Okay. Thank you. Any questions from board members?
I just have a statement, with the advent with the RDOF, Rural Digital Opportunity Fund, Internet. When you think that we're going to need as much electricity as we can get, because of these additional internet sites, we're going to be utilizing more electricity.
Geez, I'm not 100% sure that there would be too much of an additional strain on most of the folks in that area that are just receiving standard residential internet connections. I think that can be powered with an existing electrical hookup. I don't know that this is really having.
Maybe I'm asking how Charles here.
So if I may, just from personal experience, I would say that if you are thinking in terms of a data center or an area that has a tremendous amount of data servers drawing power to then receive information and then redistribute information into the internet, those facilities do take a lot of power and they're difficult to locate. So they're two separate items, but I have heard of what you're speaking of. Maybe it's a transition of thought from residential internet traffic to commercial and business internet traffic in the form of a data center. Data center requires a significant amount of power. Our homes to have internet.
Okay.
I was just, Mr. Hoagland, I wasn't sure what the question was, if it was pertaining to the site or just general question about internet access. I didn't hear the
It was
question.
pertaining to additional internet access and the availability to assist that internet site.
Okay, so typically the data for these sites is a very, very low data stream. And a lot of times it actually, they may put in a DSL line, which is kind of a business line, or they may do it without using existing local internet infrastructure. They may do it with a cell service. So it all depends on who this site is going to, who the maintenance entity is going to be for the site. They typically do have 24-hour monitoring of the site, but the data streams are very, very low.
All right, any other questions or comments? All right, Mr. Hoagland, so this gets us back to the pleasure of the board. So our options today are to make the recommendation to approve, deny it, or we take no action and it'll come back before you.
Yeah, there's nothing in there about taking no action. Michael veto provision, like that I call. But yes, and I think too, if you were to request modifications to the plan, the timeline on that would be rather tight, because I think the 30 days technically expires 2 days from now.
Right.
On Thursday, and we'd have to get into business of a special meeting, and do that.
Mr. Chairman, I have one question. Since this diagram we got is so small and us elderly people can't see real well, what is the width of the right of way going into ingress and egress to the property?
It's a 30-foot easement.
Okay.
There's an enlargement up here. I can.
Okay.
But to answer your question, 30 feet.
And there was a thing about the traffic on this to and from this property. And from what I've seen, and I ride by 2 solar farms every time I go to and from Yanceyville home. Traffic will be minimal on this thing once construction is completed. So I don't think traffic would be an issue. That's just my personal opinion.
Mr. Oakley?
What was going back to the stream setback, I think that was one thing that was still open here. The way the current proposal is drawn up, is it 50 feet on both sides? Is that the way it's currently drawn up?
Yes, the proposal currently indicates a 50-foot stream buffer on both sides, which results in a 100-foot total buffer. And that obviously doesn't include the specific width of the stream and I'm sure some portion of the banks. The question that I believe is still before you is the intent of the high impact development ordinance to require 100 feet in both directions, thus resulting in a 200-foot buffer? Or is the 50 foot on either side sufficient to meet what the HIDO spells out as a 100-foot buffer? And I do have some excerpts from the ordinance I'll be happy to put on the screen. But in my analysis, that's really the only lingering question before the planning board right now.
I think it would be worth the board's time just to look at it so they can, see what the language is. As I look at it, I don't think it's clear. So maybe that's something we can take up in the future, but anyway, I'm not going to propose we make any changes as a result of this. I would just maybe it's something we need to take up in the future to clarify.
Yeah, and you certainly could. I mean, I don't think there's anything that would stop the board today from making a determination and simultaneously perhaps reaching out to the commissioners or seeking clarification from the commissioners on this line item in the ordinance. Because it's not part of the UDO, it doesn't really, in my opinion, doesn't really run the course of a normal amendment process. Where you would review and make a recommendation first, and then the commissioners would essentially ratify. So I think that is an option at your disposal. You could request clarification. I think you do have to make a decision today, but simultaneously you could request clarification or kind of politely recommend an amendment to the ordinance to clarify. And give me a moment, I apologize. Let me find this.
And if we wanted to make a change or make a amendment for the future, we could do that as a recommendation to the board of commissioners. Right?
Correct. I mean, ultimately, the ball is in the commissioner's court. They're the final authority on amending ordinances. But I think that
we can make,
but you can certainly make the recommendation.
right.
Yes.
We can make it.
Okay. So here's what we've got in the high impact development ordinance that is really relevant to this conversation. And you can see my mouse on here. So again, a renewable energy facility is a class 1 use. And if you look all the way over here to the left, you've got the classifications of class 1. Your minimum lot size of 10 acres. This property exceeds 50 acres, so that's not a question. Your building minimum height of 40 feet. These solar panels are maybe 8 feet tall at the highest, so that's not a question. No land use spacing requirement. The 150-foot operation setback is very clear on the site plan, but the stream buffer setback of 100 feet, again, is still perhaps up for debate. And I will share this with you as well.
Yeah, I was gonna say, if you show the diagram and then the definition of stream setback, then you can see where it's a little fuzzy on.
is here's our definition of the stream setback, and I'll just read this just to make sure everybody is on the same page. Stream setbacks, all uses and industries regulated by this article shall be required to maintain a minimum stream setback from any perennial or intermittent stream as specified in the land use table in section 14.71, and that's what I just had on the screen. The stream setback shall be measured from the area of operations to the bank of the stream.
That's pretty plain to me.
So now go to the diagram and you can see what that description really means.
So here's our diagram. And I'll go with the mouse to show you that this,
No, I mean, in the Idaho
the
Act,
table,
the picture that shows. Area of operation. Then there's a diagram in there that shows how these setbacks are defined.
oh, yeah, I don't have that. I didn't save that prior to the meeting, but yeah, it's just below that table. I know what you're talking about. If you have a copy, I have a copy of the HIDA somewhere in my notes here.
But it's your interpretation, Matt, that the 100-foot stream setback will be 50 feet on both sides.
I think going by the strict letter of the ordinance, that it's 100 feet on both sides.
Okay.
But as Mr. Huffine mentioned during the last meeting, which I thought was important to note, is that would, if I remember this correctly, that would mean that the county has a much stricter standard than even the state would apply for these types of developments for perennial streams. And I'll allow you to elaborate that on it if you wish.
And if I may, Mr. Chairman, I totally agree. We need guidance. Because we don't know how to interpret this specific to the mindset or the spirit of the gentleman or ladies and gentlemen that wrote this. The 100-foot buffer. If you add those 250, you get 100. If you look at a diagram, which maybe we would clarify that for everyone. If it shows you dimensionally it's 100 feet from the top of the bank, then we don't have a question, then you know how to take action.
Okay,
But we do not have the ability to do that. We need your guidance, I think, at this point.
as in this application, your property only goes, your project only goes to one side of the stream. That's,
On both.
I'm saying if your property only, if your project only went to one side of the stream, it says 100 foot.
It would be 150 for us then, because that would become the operational setback. But so we'd be 150 feet off the creek then.
Right.
What this does, in my mind, is it takes this, the state buffer rules and doubles them. And if that was the intent of the planning board and the planning staff and the commissioners at the time that they wrote this, then that's what we need to go by. If it was not that intention, and if it was meant to be 100 feet and somebody called that means 50 plus 50 is 100, we need to know that as well, so we know which plan to provide to Mr. Hogan. If it's a stream that's on the property line, the solar farm has to be 100 feet, 150 feet off. So that 50-foot buffer is taken care of.
Right.
Because Mr.
I can
Dorduce,
give my opinion on what the intention was, but.
that'd be very helpful to
One
both of
person.
us.
The intention was not to exceed the state requirement. But I think the fact that you have an operation on both sides of the stream was not something that the language really got into. So, again, I think we need to do some clarification here, like for a class 1. If you're passing, if the stream is passing through, then you got 100 feet total, which means 50-50, right? On both sides, but the language here, if you strictly interpret it the way it reads to me today, I would probably have to go with, it means 200, because it's not considering a stream passing through
The middle of it.
the middle of it.
Or near middle.
Right, so I think there should be, some additional work here to clean that up. So I don't think the intention was to try to make it more strict than what the state required.
I'll also add to that, that when we apply the 50-foot buffer to any given stream, it's from the top of the bank. If the stream's 8 foot wide and you have 50 and 50, that's 180. It's a 2-foot ditch, it's gonna be 102 total. And if in your mind, that's how you think it was meant to be written, then that's great news. If it's contrary to that, then we accept that and we'll move on. We just need to, Matt and I need clarity, so that we can keep going. I think that, and this diagram that we're looking at is showing area of operations to property lines. And we well provided that. We're just not trying to boundary ourselves from Honey Creek, which were regulated by the state, our other permits to stay out of it.
Matt, with that clarification come in the form of a recommendation of amendment by the planning board to.
Yes, ultimately, yes. I think,
Subsequent project.
yeah, I mean, like I mentioned, at the end of the day, the commissioners can control these things ultimately. But I think that there would be a great benefit if there was uniformity in planning board's decision, the permit in line with the ordinance, and then clarification in the ordinance. Whether that's tweaking the definition or amending the table or whatever the commissioners may feel that they need to do. Again, I mean, it's ultimately up to them. So it's hard to.
Okay. All right, so.
But we can waive it now, to the board, funding.
Yeah, I mean,
We can say, hey, we're gonna give you 50 feet on each side.
the board grant this board can grant a variance from the ordinance. I guess maybe there's hypothetically a situation where the board makes a recommendation and then the planning department does something different. Perhaps that could then be appealed to the Board of Adjustment. I don't know that we necessarily want to go down that road, but I think that's a scenario that's out there. So it all just comes back to the lack of clarity on that 100-foot buffer.
So this particular 14-71 doesn't look like other counties.
I haven't done a tremendous amount of research into other counties, but I know that when the HIDO was crafted for Caswell, there were provisions borrowed pretty heavily from Alabama. Mr. Oakley may be able to recall those a lot better than I can.
I think at one of our future meetings, if you'd like for me to take you through a comparison of, we did a comparison of as many counties as we could find that had no zoning, and, we're doing something similar with HIDOs and stuff, and I still have that table where we did all these comparisons. Most of the counties are in this 100 to 150 range.
I know I wasn't aware of any double setbacks counties other than maybe Orange County, but that might be the only one.
Well, yeah, Orange County has zoning for the most part, so. I don't think they have a HIDO type document in Orange County.
Yeah, I'm just not sure.
Alamance has one for sure. Quite a few other counties, but my personal thinking here is, since there's some gray area, we could potentially make a motion to approve as is, and then we go off and do some work to try to clarify it.
All right, so Mr. Hoagland, based upon what you've seen the application, does the application meet the requirements?
Yeah, based on everything else in the application, as I mentioned, there were 3 gray areas, if you want to call it. 2 of them were very clearly addressed in the groundwater and the traffic impact analysis. And then the only thing up for question for me was that buffer. If the board wants to make a motion to approve and then also go down the path of clarification or recommendation and working with the commissioners or whatever that process may be like, then I think the board would be safe to do that.
It's the pleasure of the board. Do we have any motions?
I'll make a motion to approve as is, and we can work on clarification in a future day.
I second.
Motion by Mr. Oakley,
Do we want any input from one of our commissioners here before we?
I can only give you my opinion, Mr. Oakland. My opinion would be 50 on each side. I cannot speak for the board. That would be my take on things.
So, Mr. Oakley, thank you, Commissioner. Mr. Oakley, the motion is to approve the application as is.
And we will consider the clarification on the stream setback. At a future date. Okay. We can come up with a proposal and send it to the commissioner.
Motion and a second. All those in favor, let it know by saying aye. All those opposed, like sign. Motion carries.
You'd like to say something?
Thank you.
We can move it on with Matt directly. We really appreciate it. Favorable recommendation.
Thank you, Mr. Hutton. Good luck to you, sir.
Thank you.
Appreciate it, but we cannot leave without saying thank you to all of you and the time you put into it. And say, always try to do what they say and something. Thank you so much.
Good luck to you all.
Thank you much.
Planning department updates whenever you're ready. I'm sorry, I hope I'm not rushing.
Not a problem at all. I appreciate that, Mr. Chairman. I do not have much in the way of an update with regards to broadband, as far as I understand. They're continuing work that they're at their most recent pace and deploying, turning on new nodes, as they call them, throughout the county all the time. I haven't heard about any major perhaps Mr. Foster knows more information than I do.
You know, I talked to one of the guys that over on next to Reedsville. I'm over in Rutland, and I know that we're very close to getting internet connected. They're putting up the boxes and everything. It's probably very so. That's right. It looks good on Pot Spring Road and Ashland Road, but that's outside of the county. I know that's what they're going outside and they're working on where they're working in, but they're basically finished with the Pot Springs and Ashland.
That's correct.
Has anybody here got any internet?
How far, Mr. Oakland, do you know how far east and north they going?
Without looking at the map, I couldn't tell you specifically. I mean, the vast majority of activities kind of south Yanceyville, and then there are some stretches up towards Hyco Lake and Leesburg and so forth, and then over here stretches up towards Hodges Dairy and up towards Pelham. But it's not as comprehensive coverage as the southern.
Well, I do know that they've already have the cables in on the Brown Road, which is off of 158 east. So I didn't know how far east, north it was gonna go.
Yeah, if you want, we can pull up the RDOF maps and maybe
Go up 62.
take me a minute to find them.
They were
That map.
checking the poles or measuring poles and all that stuff back around Christmas.
I wouldn't aware how far north and east they were going.
I don't know how long it'll take them to get there. Well, we've got different companies, right? Other than Spectrum, we got White Star, and I think it's another company, Centel, something like that.
Well, Bright Star, from what I understand, is the new parent company of CenturyLink. Or Last CenturyLink, as I've heard it referred to.
No century.
The real thrust of what we're talking about here is Charter Spectrum. So let me share this with you guys. It may be a little bit tough to see exactly what you're looking at here, but this is Yanceyville, where you see the mouse. And so you've got a pretty good stretch over here to the west up toward Pelham, not all the way up toward Pelham. Hodges Dairy, down through the south. The vast majority of the south is really good in future coverage. And then a few spots over here up towards Milton and the Dan River area, Mountain Hill, Blanche and Hamer, and a little bit over toward Samora. The red, I'm not 100% sure what's happening now with the red. Those areas were awarded to SpaceX, the Elon Musk satellite internet company. Yeah, I'm sorry, Starlink. That's exactly right. And I think there have been some problems with Starlink since they were awarded. In other words, the funding is not coming their way and they're not going to be able to do it. But I'm not 100% sure. Now, Zytel is a little bit different. You guys may remember from a few meetings ago when we pulled up the map. I think it was September, October of last year. We pulled up the Zytel map. They have been awarded the state great grant funding, but that's a matching type of a process. And I believe that they've got to expend a certain amount before they can recoup a certain amount, and then expend and recoup and expend and recoup. So, yeah, let's say, I want to say their big picture project is $4 million, something like that. And let's say, they got to expend 500,000 and then they can recoup 500,000 and then spend it again and recoup it and back and forth. They're a relatively small outfit out Virginia, the Smith Mountain Lake area. And I just don't know where they may be in the process.
Mr. Hoagland,
Yes, sir.
if I may, pertaining to Zytel, the county has a $250,000 matching sum that would be paid to them, but only upon completion. Not gonna put money in it up front. When they get to work on the ground, everything's operational, the county will kick in that share. Yeah. Great.
And I think, if I remember correctly about the grant application process, having some sort of a matching component like that strengthens the application. So they were able to use that as a little piece of the pie to strengthen their application with the state. All right. Any other questions on internet? Thank you, Mr. Hoagland. Yes, sir. We got a couple more quick items to share with you. If I can find them. I still have not heard back from Mr. Doug Barker with the towers that were approved but not yet constructed. However, I did go out a few days ago and I took a quick picture of the Stephentown Road tower that was just approved at the end of last year. This is a little bit of a zoomed in photo, and this is from the gate out into the cow pasture. And I did just get an email from George Davis right before the meeting as well, who said there was a delay in the construction process due to a backup at the tower manufacturer, but it should be standing by the last week of April. So based on that, hopefully they're about a month from completion of the actual physical construction of the tower. And that's all I've got for a planning department update.
Thank you, Mr. Hoagland. Thanks for all your diligence and work, and thanks for keeping us straight.
Yes, sir.
All right, any other comments? Hearing done, ready to adjourn. All we need is a motion to adjourn.
I'll make a motion.
Second, motion to adjourn by Mr. Hill. All those in favor, right now, say aye. Aye. Right sign. Meeting adjourned. Thank you. Yeah.